Wynne to move the motion.
Thank you, Mr Rosendale, and it's a pleasure to see you in the chair as always, and I know it's highly unusual for a member of the Shadow Cabinet to speak on matters from the backbenches, so I'm grateful for the opposition whips and Mr Speaker for understanding that as a final opportunity to seek some form of closure for my constituent in a very serious matter that they have allowed me to do so. And I'm especially grateful to Mr Speaker for granting this debate. It has been necessary, sadly, for me to publicly outline the way my constituent has been let down by public authorities and by abuses of the law and NHS rules to avoid giving my constituent, Mr Hawkins, the justice that is rightly his. He has been seeking justice and some semblance of honesty and humility for a case which has already passed the decade mark. So I'm grateful to listen to the Minister of State's reply after I've set out Mr Hawkins' case. Mr Hawkins was admitted to Tameside General Hospital on the 28th of June 2006 to undergo surgery to repair a left ruptured Achilles tendon. If you rupture your Achilles tendon, you can either partially or completely tear the tendon. This makes it difficult to walk and your ankle will feel weak. The surgery was listed for theatre in the afternoon under the care of orthopaedic consultant surgeon Mr Ibisi. The surgery was postponed and arranged for later in the evening. My constituent believes the surgery should have been postponed until the next day. This would have been the most simple and sensible solution, as it would have meant Mr Hawkins would have remained under the care of the same surgeon. He believes the surgery was not postponed until the following day, as this would have meant that the hospital would have been in breach of its 5-day target for a patient to receive treatment or surgery after attending accident and emergency, which in turn would have meant that a government target was missed. Records indicate, however, that the surgery was instead carried out by Dr Manikanti, assisted by Mr Kumar. Mr Hawkins states that the change of surgeon was made without his knowledge or his consent. Both clinicians have subsequently left the hospital and the country, with the names and titles of those carrying out the surgery subsequently disputed. Mr Hawkins states that the surgeon made a critical and crucial clinical error. He believes the surgeon misunderstood the positioning of the two diagonal structures forming part of the modified Kessler structure. Instead, they were brought to the surface and closed, which permanently fixed the repaired Achilles tendon to the rear of his leg. On the 7th of July 2006, 9 days after the surgery, the plaster cast was removed, revealing an open wound between the two structures. Steri strips were applied and in an attempt to close the wound. However, in his records, the duty consultant wrote that the wound had healed very well after surgery. Mr Hawkins states that despite being aware of this error, the hospital failed to correct the mistake by releasing the repaired tendon from the rear of his leg as soon as was medically possible, allowing serious adhesion and tethering to form as the structures disintegrated. On the 12th of January 2007, Mr Hawkins was discharged from the care of Tameside Hospital. Throughout the previous months, the repaired Achilles was continually swollen due to the aggravation of the fixation. Mr Hawkins raised concerns which were ignored. Thereafter, weekly and monthly appointments at the hospital were required. Mr Hawkins believes that he was discharged by Tameside Hospital before he was clinically prepared and regardless of his condition. He feels this was to conform to government targets, and he immediately made a complaint through the Hospital Trust's internal complaints procedures. Mr Hawkins believes, and not unreasonably, that on receipt of his letter of complaint, the Trust should have called him in for an examination and a scan. They should have admitted a serious problem had occurred, and they should have carried out a further operation to release the Achilles tendon from the rear of his leg. In Mr Hawkins' mind, the matter would then have been resolved at that point. However, the Trust decided to take a different route and instantly instructed Hempson's solicitors. While Mr Hawkins is obviously concerned about the clinical errors that occurred, which have caused lasting damage to him, he is rather more appalled by the actions of a variety of organisations that followed, which he believes were deliberately designed to cover up the fact that a clinical mistake had been made, caused primarily by the replacement of a consultant surgeon with a junior doctor. In 2008, Mr Hawkins instructed a solicitor who requested the disclosure of all full medical records. The Trust passed this request on to Hempson's solicitors. However, in the immediate period after his request, Mr Hawkins only received a very selective number of his own medical files by Hempson's. Mr Hawkins' solicitor failed to ensure that all full medical evidence was disclosed within statutory time limits and failed to apply for a court-controlled disclosure whilst knowing that records he had listed were missing. Mr Hawkins' solicitor instructed a clinical litigation medical expert who produced a case closing report which failed the objectivity test, making the report invalid. The Trust and Hempson solicitors initially failed to disclose relevant medical records and only did so after continued and considerable pressure from Mr Hawkins himself. I will give way.
Thank the Honourable for giving way. Making a very compelling case and strong advocacy for the difficulties that his constituent has faced. But would he agree with me, this flags up a wider problem, that he's talked about lawyers and solicitors at a very early stage in the process, and the current system of medical negligence in hospitals pushes defensive medicine, defensive approaches by hospitals. That fundamentally needs to change. It's not good for doctors, it's not good for patients. And would you perhaps think no-fault compensation may be a good way forward?
Absolutely. The Right Honourable Gentleman makes a very important point there, because, as Mr Hawkins himself acknowledges, had his complaint been taken down a different route by the Hospital Trust, and had they then accepted that they had made an error clinically and decided to put that error right, I wouldn't be standing here today raising Mr Hawkins's case on the floor of Westminster Hall. Now, Mr Hawkins continued with his complaint, and in 2013, the Trust eventually conceded, and his remaining medical records were fully disclosed. On analysis of the records, it was plain to see that omissions were apparent, as well as pre-action protocol time limits being exceeded. In response, Hempson's solicitors sought the opinion of a medical litigation expert. A report was produced, but this was based on selected medical records I mentioned earlier, as well as the falsified information. Mr Hawkins believed that this would fail any objectivity test, making the report invalid. Now, Mr Hawkins had involved the Information Commissioner's Office on 2 occasions, in 2009 and 2013. In both instances, they judged that the Data Protection Act 1998 had been breached, and the Trust's failure to disclose relevant medical records on several occasions was the breach in case. After much time and effort, on the 11th of December 2013, the new management team at the Trust finally admitted to maladministration and awarded remuneration for that maladministration. In a move that Mr Hawkins believes was an attempt to close his complaint and prevent the case going back to the Information Commissioner or to the court for disclosure, the new management team disclosed that they would no longer discuss actions taken by the old management team. In addition, Mr Hawkins believes that the Limitation Act 1980 was breached from 2008 and that Civil Procedure Rules 31 and 35 were breached in compiling medical reports, as the medical experts failed in their duty to the court to be objective. The delays in disclosure of information meant that Mr Hawkins' complaint to the Parliamentary and Health Services Ombudsman was ruled out of time. My constituent believes this makes a mockery of the Trust's failing to disclose his medical records within statutory time limits, which he believes the Ombudsman ignored while upholding the strict time criteria on himself making a complaint to the Ombudsman. Mr Hawkins appealed the decision on several occasions when the evidence was retrieved through the Information Commissioner. However, he was unsuccessful in overturning their original view that a letter from the Trust indicated that the complaint was closed in 2007, which he utterly refutes. Hempson's solicitors later apologised and admitted that the letter did not clearly state that the local complaints procedure was closed. However, the Ombudsman still refused to investigate the complaint, and by doing so, Mr Hawkins feels that they have assisted the Trust to conceal the cause and the effects of a clinical error. In 2013, Mr Hawkins wrote to the NHS Litigation Authority, considering the Trust were not reporting clinical mistakes. Initially, the NHS Litigation Authority would not get involved and requested my involvement, which I duly offered as Mr Hawkins' Member of Parliament. 2 replies were received which indicated that NHS Litigation Authority were involved despite previous assertions and written evidence that they were not involved in the case. Mr Hawkins was notified in writing that the Trust, on receipt of his letter of complaint, had instructed Hempson's solicitors in January 2007 with the NHS Litigation Authority directly instructing Hempson's solicitors and the Trust from November 2007 to February 2009. Hempson's solicitors were aware of a breach of the Limitation Act and Data Protection Act when they disclosed to Mr Hawkins his missing medical records in October 2009. This means that the Trust and Hempson's solicitors had illegally avoided disclosing all full medical records within statute time limits and successfully passed the 3-year limit for litigation. Mr Hawkins believes this indicates the NHS Litigation Authority were aware that rules had been broken, yet failed to take retrospective action based on the strength of evidence disclosed in the NHS Litigation Authority to the NHS Litigation Authority in 2013 by Mr Hawkins. The actions taken by the Trust, assisted by Hempson's solicitors and the NHS Litigation Authority from January 2007 to December 2013, clearly indicates the Trust were covering up a clinical incident and its cause. With so much time having passed since my constituent first exited the operating theatre in the summer of 2006, I hope today that the Minister of State for Health will be able to afford Mr Hawkins guidance and support in this matter and finally bring to some closure what has been a dreadful episode for my constituent.
Yeah.